So we are beginning the Policy and Governance Committee meeting. I'm going to look over Kim's shoulders for the start. So this is call to order. Jennifer and Lisa, can you hear us?
Yes, thank you. Can you hear me?
Yes.
And yes, I can hear you all. I hope you can hear me.
Thank you.
So we got both of you in here. So I think the first issue was that we were going to move the discussion items around. So if we have a motion to amend the order of the items for the 700, for the order is the following: 700 series, primers, 303.2, 504.06, 504.06 R1, 503.01, 503.11, 503.11 R1, 503.11 R2, and 603.03. Do I have a motion?
Mitch, I think we just need everybody to agree. We
Oh,
should
do we
make
agree? Okay.
motions and action in a committee meeting.
Yeah,
So if we can
sounds
just get
good.
everybody to agree. Lisa and Jennifer, would you agree to change the order of the agenda for tonight?
Yes.
Okay.
So I didn't have to go through that full list. You could have interrupted me at any time. Okay.
Make you work hard.
Thank you. So let's go ahead and start with the 700s series.
We need
Wait,
the minutes
oh,
first.
yeah, we need a motion to pass the minutes from the June 23rd, 2026 meeting.
I move we pass the minutes from the last meeting.
Second.
All in favor? Aye.
I
Anybody not in favor? Nope. Okay, so we are moving on. To the 700 series is the biz primarily concerns the business department and fiscal management. We've been at this one for its first reading was March,
I think so.
February. Okay, so
March, yeah.
is there anything that board members would want to add or discuss from the 700 series?
This is Jennifer. I thought that the revisions reflected our discussions from the past, and I'm satisfied with the current shape of those policies.
agree. It was a bit of a long road to get here, but I looked over everything a final time yesterday, and I thought to myself, I actually don't have anything I need to talk about with these.
Okay, seeing that I have no problem with it. So with that, we will move on for okay as is. Moving on to the policy primers that came with last meeting. So there's quite a few in here. Is there anything that anybody wants to go through off the top of their head? I know that Director Horn Fraser caught some issues with things needing to be crossed out. So good job, Director Horn Fraser, for
Thank you.
being on the ball on that one. Was there anything else that either of you would like to talk about on these documents?
No,
This,
oh, go ahead, Lisa.
no, we're both pausing the exact same amount of time to let the other one go first. I don't have anything that I wanted to flag on these policy primers.
Yeah, I think it's clear and it feels like it reflects both the state direction and then also a few things that are specific to where we're heading and thinking with respect to our financial oversight committee and the changes that we're making going forward. So I feel like these are also in good shape.
Anybody else that is here just, yeah. So moving on, so we're good with the primers. I believe we are now on to 303.2 and any comments from board members on that one? I know that the we took it to our legal department, and I don't believe I'm breaking anything by going through what they told us. Policy looks okay. They Allers recommended deleting the last sentence in the second bullet point, as that will depend on specific situations. So, and then Kim got that. If any legal issues or challenge arise from the hiring process, the members of the board participating in the process will recuse themselves from any board action. I'll wait for either of you.
No,
This is, oh, go ahead. I'm going to say it's fine. It sounds like you have something.
No, my only concern last time that we looked at these was I just wanted legal to look at it because it seemed fine, but always better safe than sorry. And they did look at it. So I think we're in good shape.
Okay.
I feel the same.
Same way here. Anybody else? Okay. So this is going faster. I had little faith, so I apologize for wondering how fast this would go. But next we
Oh, we haven't gotten to the hard part yet.
yeah, that's partially why I wanted to move those to the beginning. So starting with the 504.06, the student activity program, and we'll do this in conjunction with 504.06 R1, and this is regarding eighth grade participation. Hopefully I can speak that straight. In athletic contests and sports, the high school level. This was a law put into effect by the state. And now all school districts are scrambling to get it in at the get it done in the month of July because it went in effect July. And as Director Williams reminded us in email earlier, Dead Week ends on Friday. So sports start up really soon. So I'll let you two start with any thoughts, questions, or concerns.
I had just one note in each of these two policies. So I am looking first at 504.6, and in the, I guess it's the third paragraph highlighted in green. I was not sure if the third sentence was redundant or there's a meaning that I am not clear about. So that sentence is, students may not compete in both programs during the same sports season. And the sentence before says an eighth grade student who participates at the high school level cannot also participate on an eighth grade team in the same sport during the same season. So my question is that redundant, or does it mean that an eighth grader cannot participate in both an eighth grade team and a high school team for different sports for seasons that are concurrent?
You're talking about like situations where I think soccer and track and field are ones that overlap.
Yeah.
Right? Do we know?
Yeah, our understanding on this is that they would be able to do that. So if they were, they really need to make the declaration for the sport. And so if you were for example, the one you just used, Director Lingo, if they were a varsity track athlete but wanted to participate in junior high soccer and those seasons overlapped, the student athlete would still be able to do both of those. What it's trying to clarify is that they're not able to participate, of course, in varsity track and junior high track, or excuse me, high school, I should use the word high school track, or middle school, junior high track at any point, even if those seasons aren't concurrent, even if they'd be separate. So that creates some logistical challenges for us.
So like soccer is the perfect example because it competes, girls soccer competes in the fall for middle school, but it competes in the spring for high school. So the way you're saying is a child could not participate in eighth grade soccer in the fall and then try out for high school in the spring. So they have to kind of be sure that they want to do it.
So our high school coaches will need to run tryouts basically ahead of the middle school opportunity.
Well, I have thoughts, but it's not worth the time because we have a lot to do. Did you two catch that from the speakerphone?
I did, and my understanding is that the prohibition on competing in both eighth grade and varsity is part of the Department of Ed's rule making.
Yeah, that's not our determination. That was the, straight from the law. The other example with what we were just talking about with soccer there, we think there's probably an opportunity next spring to do something different in that sense and take advantage of the spring season so that those tryouts wouldn't be so far ahead of the actual high school season. So not to confuse you in the timing of those things, but this first year, you know, we'll learn a lot in terms of the calendar, but then there'll be another opportunity knowing this is the environment to do this next spring that we didn't have this year.
This is following state law or the Aller's recommendations in this document, correct?
Yeah, so state law is to allow the eighth graders to have the opportunity, and then there's some guidelines there about how that opportunity can be facilitated in districts. And so, you know, we've shared with you that really those two parameters we'd be looking at in the Iowa City Community School District would be for, again, tryout for the varsity level or really a numbers consideration at those lower levels. And so those decisions would be made in conjunction with the building level athletic director and principal to determine if there's a need for additional numbers to field a team at those lower high school levels, and that decision will be made ahead of the tryouts.
Director Degner, can you just go through what exactly allows a student, because I'm sure someone will probably listen in on this and be like, well, what is, and then we'll get an email. So what exactly allows a student, what ways can an eighth grade student play a varsity sport or play high school sports?
Yeah, and so that's what I was trying to frame there. So the really
Yeah, I
two
know.
options for an eighth grade student would be kind of think about it like exceptional athletic ability, right?
Yeah.
So they would try out, they're a standout, they're good enough to participate at the varsity level right away. That's identified through that tryout process, and the coach then would have a meeting with the athletic director, principal, and parent to kind of agree to expectations and what that's going to look like. The other option would be, again, that they would hold a tryout and say, we need, you know, 5 additional players to be able to field a freshman basketball team, freshman girls basketball team, because we don't have enough student athletes. And so then they would hold a tryout for the eighth graders and select 5 of those eighth graders then to participate on that freshman level basketball team in that circumstance. So it's really a participation consideration. Do we not have sufficient numbers, or it's that exceptional athletic ability that would then qualify them for that varsity level of competition? We're not looking to create a situation where we pull eighth graders up that then would create a playing time issue with our freshman, sophomore athletes on JV level competition. So really trying to clarify that it's either numbers based or it's exceptional ability to get that varsity competition.
This is one that I think wait and see. What I'm going to talk about is more of a wait and see. I'm not saying do any action right now, but one of the concerns longer term that I could, from talking to people, is students redshirting the eighth grade year to be more ready to have that extra year of development before entering high school sports. That's one of those weird, it happens now, and because the opportunity for scholarships are there, and that is one that I'd like to hear more about if it's happening. I think it'll be a statewide discussion more so, but
And I think what you'll see is it'll trickle down to the 7th grade level now. The redshirting.
The redshirting.
7th grade.
Interesting. Jennifer or Lisa?
Oh, go ahead, Lisa. I just have one small question.
No, go. Did that answer your question, Jennifer? Because I still
I still have some question about it.
I think it's basically.
And so I'm just wondering if it's not clear to me. I understand the example of, you know, the girls soccer in middle school and in high school, that season is not the same season. And so I'm still getting tripped up on the the end of the second sentence of that third paragraph, where it says an eighth grade student who participates at the high school level cannot also participate on an eighth grade team in the same sport during the same season. I'm wondering if that should be same academic year or something like that, because it sounds like from your example, they couldn't do middle school soccer and then later high school soccer. Is that correct? In the same academic year?
Correct. Yeah, it's probably not, I mean, we use the recommended language, from the policy provided, but I think your clarification there probably is a good one, because it doesn't necessarily capture the whole issue. The second sentence you were asking about is somewhat redundant, or it's a further clarifier that I think they're attempting to make in the language there.
I mean, we can change it to academic year or,
Yeah, I mean, I get the intent and I don't have a problem with that. I just feel like our, that it's that paragraph is not immediately understandable by everybody. And I would love it to be that at some point, but if what we're doing is saying we really need to have something to work with immediately, I am okay with what the meaning is as we have talked it through, and that I think you can interpret from these words, but it just is a little bit more work than I think it needs to be. And so I'd love to, over time, make that easier to understand, especially as we kind of figure out how people are talking about it.
My guess is the people who wrote this didn't realize that there are just a handful of sports like girls soccer and is golf one?
Yes, golf is one, that's one that's actually has a practice start date here of Monday that we were concerned about, with the timing of all of this, so that's another good example, yes.
Yeah, so my best educated guess is that the people that wrote this were not thinking of like girls soccer and golf that have middle school seasons separate and apart from the high school season. And that's just my guess about why it's worded that way, but I think it is unclear, although I also am I think we've been very clear as a district that you just can't do both sports. And it doesn't matter if the seasons overlap. It doesn't matter if they don't overlap. If you're an 8th grade student who is going to play in high school, you do not get to play on your middle school team. And so I think there's enough clarity there that maybe we don't amend the language now, but we put it on the back burner to see what comes out of Des Moines as far as clarity as the year progresses.
I would tend to agree. I would agree with you, Lisa, because my example that I used was because I thought they were at the same time. So
Yeah,
my own ignorance in the example. So
it's not on most people's radar because most sports are that like middle school football is the same season as high school football. So and same thing with basketball. And track is the same. So anyway, I don't think it's on people's radar.
Even even if we think about golf, right, we don't have that at the middle school level, like we're sitting here thinking it might only be
Might just girls soccer.
Mhm.
Yeah.
Anybody else in the room have any questions?
I had the same question on when you study. I've read the next to last paragraph where in green it says a high school student who participates, blah, blah. That would, the way it's worded right now, to me, that would mean that an 8th grade student is participating in a school sponsored program could not also participate in a non-school sponsored. And I assume that's not the intent.
Whoops.
Yep, sorry. I think he's talking.
This is wasn't it?
So I believe it's a high school student who participates in school-sponsored athletics may participate in non-schools. I think that's more referring to if the student's playing a club team.
That's how I interpreted it.
Yeah.
Right, but I think he's asking if that applies to 8th grade students as well.
And it,
Because they specifically say high school, not
Yeah.
8th grader.
Mm,
I think there's several examples of what a district can do here and suggest for policy. I think sometimes, I haven't seen it as prevalent in our district, but you get into some conflicts with kids choosing their club sports over high school competitions. And then that creating an issue, right, about if they're not attending the high school competitions and they're going to their club sports. So some districts take a policy where there has to be a much more strict approval process to that, even if you see the red scratched out language. That was an edit we're suggesting from the standpoint that we don't really seek out that approval. That hasn't seemed to be an issue, that we need that advanced approval from the high school principal or AD, that the buildings have seemed to work those conflicts themselves. So I think eighth grader or high school student, Charlie, the policy serves us.
So you think the wording is okay?
Yeah, I think it's fine. Yeah, we don't really run into that as a concern either at the middle school level, that we need to clarify that.
Okay, thanks.
I had one other question. As part of this process, I know that there is a health form that a physician for an eighth grader has to certify that the eighth grader can compete at the high school level, but I didn't see incorporated in the policy, and I'm looking at 50406R1, that we are requiring in the policy that the health form be completed or submitted. Are we requiring the health? I guess my questions are we requiring the health form, and then are we assuming that under number 2, the parent athlete manual, is that how we're incorporating the health form requirement into the policy?
Yeah. So thanks for that clarification, Director Williams. We think it's covered in the policy, basically, when it addresses any eighth grade student participating in high school athletics must meet the annual athletic physical exam requirements applicable to all student athletes. I think you could further clarify that in policy, but when it speaks to what those physical exam requirements are, that's an additional physical exam requirement that we've talked about, would have to be communicated to those student athletes. So we've worked with that on with the principals and the athletic directors to have that as part of the process that's implemented. I do think you have some language there that would cover it, but you could also further clarify it, or that's something we could also bring back for further policy addition, just like with this cleaning up the academic year. So I see your point there, that it's not specifically called out, and that just might be a wise thing to do.
Yeah, I don't have any huge heartburn in changing it tonight, but maybe if we could add that to the cleanup. I just, how my brain works, which is not how everybody's works, right? But like if I see 1, 2, 3, I'm like, all right, these are the things I have to do. And if 2 really has a second thing hidden in it, it just gets sometimes confusing.
It is on the website, Lisa. I just looked at it, just as Amy.
Oh,
But
okay.
I don't mind bringing it forward either. It's on the website and that parent athlete manual. under
Yeah, they
general
have it
rules.
in the like procedural stuff, but you're talking about the link there that's on number 2 in our, yeah. One question I would maybe have for the board would be when you would want to see, these edits back. I think the other thing we can anticipate is if you do approve this tonight, there might be a couple other things that are helpful to be clarified as we travel through the fall. Would we be okay to bring those edits back when the 500s come back, or is this something you want to see cleaned up sooner than that at your next P&G?
Just another reminder, they're still doing the rulemaking process, so they're in the emergency rules right now.
Yeah, I prefer to,
Sorry.
I'd prefer to wait until we get the updated rules from DOE and then kind of do one mass cleanup.
I'm on board with that.
I am too. What I'm hearing is that nothing that we're talking about is substantially changing the meaning. It's more clarifying and making the policies more accessible to a reader, and we can hang on to these notes until we get the final guidance.
Okay, moving on to 503.1 student conduct. Do we want to do these one at a time, or do we want to just approach it all at once? I'm fine either way, because they all kind of tie in with one another.
I mean, my overall understanding, and this is for the team, and maybe correct me if I'm wrong, but again, these policy changes are because of changes the legislature made to the law that we have to comply with, not necessarily because they're policy changes that we would necessarily adopt on our own.
Yeah, this is Amy. Senate File 2428 is quite extensive. And so you see ISB's team taking a crack at the various policies related to whether it's student discipline, special education in there, is information tucked in around different employees' requirement to view the IEPs for us to be able to track that in different ways. And there's an employee reg that went with this as well, where our teachers have to be given up to 3 days, depending on the circumstance, for leave purposes. And so we have that question from the attorney. Our particular policy for that would just refer to the 5 negotiated agreements that we have. And so as we've worked with legal on that specific policy, they said our policy as it reads is fine to have right now. When we go back into the spring session with negotiations, we can have that added to the negotiated agreement at that time. So yeah, all of these are just related to Senate File 2428. I shared with a few of you, there's, a lot to the law, but there's a lot of vagueness as well. So we continue to rely on the legal team for, as we move through this for additional understanding. I can see us also receiving more guidance as we try to implement this to the best of our ability. I think right now we wanted to get it in front of you, so you had awareness of it. The team here is working hard to put the information together, not only to roll out to our administrative team, but also to our larger staff. So we're learning along the way and doing our best. I know the team has also met recently with some representatives from CEA on this as well.
Rich, you don't mind?
Yeah, you can go and then take a turn.
It's my interpretation of these changes to legislature wants just to implement in regard to student conduct, that none of these changes would interfere with our ability to address student conduct issues in the way that we are addressing them now, which is restorative in overall nature. Is that reasonably fair to say that at this point?
That we can continue with restorative practices and so on and so forth. Yes, that's actually an expectation, because a part of it is that there's like these mandatory reentry kind of meetings that have to take place. And so we already have reentry meetings. We just need to translate that over to what it looks like for readmittance or a removal that's not a suspension. So we still plan to wrap it with restorative practices.
Thank you.
I'll take starting with 503.RR1R, disruptive behavior. So student cannot be readmitted to a classroom if all criteria, cannot be readmitted to a teacher's classroom if the criteria are not met. So student was removed to an assault due to assault on teacher, and teacher does not consent to allowing the student to return, then what happens?
And so the board, is my understanding, you all would get a request for some type of alternative placement or something like that that's more substantial than a temporary removal.
So it'd be like putting the student in another classroom in the building or another building altogether.
And that's where it gets tricky, because at the building level, principals can try to figure something else out. If there's a second, fourth grade class, they can try to put them in a different teacher's period if the same subject is taught. But there's some circumstances where that's not going to work out. And so that might be a larger conversation.
So we'll have to design a policy around that, I'm assuming, or do we have a policy that caters to that situation?
Well, you all, as a board, will you all might need your own policy when these things come and land in your lap. But there is this piece where there's a oversight review committee at each attendance center, right? So like all of the buildings will have their own oversight review committee. And they'll work through some of the pieces around what processes look like, but then it's coming to you all's lap. If it looks like it's something extensive or there's no other place to put the student, or they're asking for a longer stay away for that child.
So I guess this, it's can of worms that I didn't expect to open up, but, and so I guess the next question is, what steps are the parents involved, and who steps in to ensure learning on the part of the student is not missed? Because this doesn't seem like a fast bureaucratic process per se, because like it happens, then do we have an emergency board meeting to approve? Because if it happened, because we don't have the first meeting in November, right? So it happens that after the fourth meeting in October, we don't have a meeting. Oh, I don't remember what. No, it's the second meeting that we skip in November. So it happens after the first meeting. The day after, for example, then that student goes without a placement until the second meeting, or the first meeting, or the second week in December. So it's like a huge gap there that I think everybody on the board would probably say that we need to figure out some way to make sure the student is learning, but I don't know how that looks, so.
Teachers are committed to,
Yeah.
probably getting packets and like interrupt if you all see areas, but if they can be placed online temporarily until we figure it out, we'll try to do that. We're gonna work as best we can to make sure that student doesn't miss any education, especially, in cases where the student might be in our special education program. That compensatory ed piece is huge, so we're gonna do everything within our power to make sure that they have learning in front of them in some way, shape, or form.
That student work piece is a part of the policy, that if a student is removed from their classroom, it's the teacher's responsibility to provide the student with the academic work.
Yeah. Even if they have the work, parents aren't home to give them that work. Yeah, like I said, it's a large can of worms to open up. Then one of the questions that I have is it relies on meeting with principals. And who is the backup person? Is it the behavioral interventionist, the SFA, facilitators? How we decided that, yeah.
That might be building by building, because it's principal designee, so they can decide, like, hey, I have to step away, and whatever, you got it. And so they might put their assistant principal, or it might even be their counselor if they're BI, or their, school facilitator isn't available, or any of their APs. So like, the principal gets to designate who the next in line is.
What if the principal's gone from the building a lot for meetings and things like that?
They get to designate who the next in line is. So it's the principal or principal designate is how it's identified. And we'll get more guidance.
Yeah,
right?
no,
So
that's.
we can't wait to get it.
Is
But
this another one of those cases where they're still working on it at the
Yes.
state? And,
I'm hopeful.
okay, hopeful.
There's a lot of gray in there, and they've given us a nice skeleton to work with, but some of the questions I was remembering that were coming up was, here's the example. So an elementary student has to be removed for 30 minutes. That's clear. They can go back to the classroom, right, under some guidelines. But with a secondary student, they're to be removed from the class and then not return to that class happens again. So presumably the next day. The question that was posed was, well, what if that teacher has that student for a second class later in the day? Does it mean it's per class or per teacher? So like tiny nuances like that are just things that we know we're going to encounter. We're going to have to do our best and implement the best we know how until we receive further guidance. And yes, we'd love to have it all buttoned up now, but we're doing our best to go forth with what we have in front of us at this time.
I
Jennifer?
had Some question just about, I'm looking right now at 503.1 student conduct. And so I know that this is not a new policy, but I was rereading it and had some questions, and one that's connected directly to the new law. And so first, in the end of paragraph 3, there is a list of disciplinary measures. And then 1, 2, 3, 4 paragraphs below that, there, the last sentence says, a restriction from school activities means a student will attend school and classes and practice, but will not participate in school activities. So I was interpreting that to be yet another disciplinary measure, and I'm wondering if we would just want to include that in the list up there at the bottom of paragraph 3, because it seems to me that a restriction is another form of disciplinary measure, but it's not exactly defined. And so that was just something that I felt was a little bit more gray than we might want it to be. And then a connection to the new law, toward the bottom of that page, there are basically the decisions that could be made about the consequences or the outcome of what are the disciplinary measures that will be used. And I'm wondering, is that now, will that be decisions that are made by that, the committee, the building, I forget what the term for it is, but the building committee? Or I'm just wondering if the new law has any impact on the decision-making process of the items listed toward the end of that student conduct policy.
That's a great question. Does anyone on the team feel like they have a good answer?
About this with reading back to the discipline protocols that we have in place with our comprehensive behavior approach, and also tying it to the Department of definitions for behaviors. Several years ago, a committee met and had multiple representation from community members and teachers and administration, where we looked at defining those behaviors as majors, minors, and then also suspendable types of behaviors. As a group, when we met, we asked the union to take a look at that and see if we're all on the same page of what those defined behaviors would be, and then when would we look at what a teacher removal is. And we were thinking that would fall, we have it as one of the majors, right? Would be a potential teacher removal. If we're on the same page with those definitions, then it would also align with what consequences could be imposed for students, depending on the type of infraction that takes place. So we're hoping that will anchor into what we have in place, but will involve the union with those decisions.
And it seems pretty seamless. So there's times a removal will not, warrant a suspension. That's probably the biggest change, because usually a removal is a major. So, or it's in some way, shape, or form.
For nonviolent, right? We have major, we also have major office assistance required. So it's just trying to, again, anchor back to the work we've already done. And I think that makes sense for us.
So then would it mean that, thanks for that background, would it mean then that we're not yet in a position to really answer that question? Like it kind of depends on the work that's going to be continuing in the next weeks and months, or?
We hope to have that understanding in place before the start of school.
Okay.
If it does align to the CBA, the Comprehensive Behavior Approach, the goal would be to have that information online and available to parents as well.
Jennifer, is your question around, can a teacher determine if a student's going to be suspended, or is it the principal that determines the student's going to be suspended? Is that your question?
Well, it's generally just what are, for any of the disciplinary measures, like I guess is the new law, does that mean that more of these decisions will be the responsibility of, shoot, and what's the name of the
Oversight.
the committee? Yeah, the building level team.
No, we wouldn't want anyone to have to do that, because I think that would get us in some trouble with, right, like, all types of things, like, we want some
Yeah.
continuity, between buildings and how we operate as a system. So even though those oversight review committees, they have some autonomy, right? They have, like, in regards to what they're talking about in the system around their building. We already have a plan to meet as kind of like a super group, to bring all those oversight committee, review committees together so that they can kind of share what they're doing. We can figure out some way for some type of continuity, and they can, like, maybe even help create a template or whatever that they'll all use. So they'll have voice in it. They'll still have some autonomy there, but we know that we need some type of continuity to keep from it being like, why is this happening over here? Why did my child get this over here? That's not fair. So, we're gonna anchor back to our CBA, like Kate said, and, support those oversight review committees as best we can so that there's some continuity.
How do you envision these oversight committees working?
Well, we called in ICEA, to and some administrators.
Yeah.
And sat down to kind of like have a think tank. We had one session, we'll have another one coming up, but basically we, are kind of shifting what that looks like in regards to the selection process, because each building has to, nominate and select or 2 teacher representatives. That's not us. So, like, just making sure that teachers union is, a part of what that process looks like. And so they're in the middle of discussing that and sharing that back, so that we can make that a part of the overall protocol.
This would be a good topic for maybe an October meeting once things get
I think so.
sorted out.
That sounds fair.
For sure.
We have a meeting on Thursday to discuss that as well. Okay.
The other thing I would just go to point out is the law does a nice job of continuing to differentiate disciplinary measures for gen ed students versus those students who have been entitled for special education. And so that's another kind of piece that is a little bit trickier to work through too, but procedurally we know how to work. We're in pretty good shape, of course, with knowing about when to call, for example, behavior manifestation meetings and that sort of thing. So the law does go as far to, spell those things out as well for us. Lindsay, would you add anything additional?
We have a process for if a student with an IEP is removed from the classroom. There's specifics in the law about holding an IEP meeting, so we have a process for that, as well as a process for counting the number of period days students removed, so that we're accurately holding those manifestation meetings as needed.
Thank you.
And this oversight committee is held by teachers, correct?
Well, the principal is a member,
Okay.
2 teachers, and I want to say the 4th member is like.
A counselor.
Yeah, counselor or interventionist, something.
Yeah, so the oversight may include 2 teachers, 1 administrative employee, mental health professional, behavior interventionist who works in the attendance center who must be selected by the principal of the attendance center.
Is it okay to move on to another piece of this? Actually, I think we touched on this one already, but I had another question about 503.11-R1 disruptive behavior removal procedures. We have been talking about, under multiple nonviolent disruption removals, it's just a small detail. I think we've been saying that the principal or designee would be in that list. And so I just wanted to note that there. But then on the at the end of the section on violent disruption, it says the principal must impose the maximum disciplinary action allowed, and then it says when it's must do this when the student's conduct, statements, or other actions are severe or pervasive, result in a request from the teacher for maximum disciplinary consequences. So my question there is, how will we define severe, pervasive, and maximum disciplinary consequences? I mean, I know that these are very, pretty subjective, but I also know that people will have varying opinions about them. I don't know what guidance we have on how to define those.
So we've defined it, we've looked at what they've already put out and kind of
Okay.
added to some of that definition, but this is something that you all will be able to take a look at in October probably. Like we've already kind of pulled some definitions that will be helpful to our administrators when they're trying to figure out what to do. But we're gonna stick as close to what the DE puts out. Yeah, we're gonna vet things through our lawyers, so to make sure that we're understanding it properly.
Okay, thank you.
Jennifer, I know you, we had a similar question that when we were attending some training around this, and at that time, the lawyers on the call said that there wasn't a specific definition around severe pervasive. So what Laura's saying is, we're going about that work here internally until and unless we find out, more around that. So we've got a lot, people have similar questions to what you're having there. That's another great example of things that are being left unanswered. I do, want to just say how important that work that we've done in the past around that comprehensive behavior assessment, pulling together both what MTSS should look like for social emotional behavioral health, as well as on the flip side, what do behavior infractions as defined by the Department of Ed, and then from there, looking at what those behavior infractions are and us determining and doing a ton of work with our buildings at the time, as well as community members like Kate was referring to, really puts us in a great spot because we've already defined what minor versus major is. I'm glad to hear that, ICA is going back and looking at that as well so that we can have some agreement upon that. We're starting from a really healthy place in that work. We've got a lot of questions to kind of fine tune it. But it feels good to have that amount of work done so that consistently we're applying practices and procedures across 28 attendance centers, and that we're not starting to work from the ground up.
And I'm happy to share
Great.
the definition we have thus far, if that's helpful. If not, we can wait till we bring it back up. It's up to you.
That document exists online currently, correct? Is the CBA online?
It's the CBA, but see, where
Go
we
ahead,
define it severe and pervasive is in our internal documents that we're working with now.
Yeah, why not?
Severe means conduct that is serious in nature because of its intensity, potential for harm, or actual impact on the safety, physical well-being, emotional well-being, or educational environment of a student or staff member. A single incident may be considered severe if it's sufficiently serious, even if it has not occurred previously. Examples: credible threats of violence, physical assault, serious intimidation, extortion, displaying a weapon, severe verbal abuse involving threats. Pervasive means conduct that is repeated, persistent, or widespread, such that it substantially interferes with the student's ability to participate in or benefit from the educational environment or significantly disrupt school operations. Pervasive conduct is generally characterized by multiple incidents or an ongoing pattern of behavior rather than an isolated event. Examples: repeated harassment over several days or weeks, ongoing bullying through social media that carries into school, continuous instruction despite internet.
That's great. Thank you.
Thank you.
Mitch, could I just ask here?
Yeah.
Here, some point maybe the staff can put together a memo for the board that outlines the board's responsibility in making decisions about whether or not a student does this or that. I'm having nightmares sitting here thinking about what I'm being asked to do and have no idea, no standards, no experience, no training, nothing to rely on.
I'm really interested in this part of what we talked about earlier, of things coming to the board and the removal of the student and switching schools, or how that will be implemented. But since the law just became official 4 weeks ago, I understand that you don't have all the answers as of right now.
And to that point, Mitch, it occurs to me that we may want to consider, and I don't think this is a discussion for tonight, but we may want to consider an approach to that where if it is the case that the board must be involved in a decision and the board is not meeting in a timely manner, maybe we do a rotating group of the board, is similar to how we do for some other purposes. That could just meet on a shorter notice as is suitable for the situation.
We can work on that and get back with y'all.
Thank you.
Lisa, did you have anything to add?
No, thanks.
Okay. Unless there's any other questions or comments. I am speaking because that covers it all, correct? Yeah.
Just wanna make the three of you comfortable with bringing the 8th grade eligibility policies to the action items tonight under that emergency
Yes,
procedure.
I am. Are you?
Yes.
Yep.
I
Yep.
Thank you, everybody.
I did just have one question about 603.3,
Yep.
the special education one, if that's okay. And I think it may just be my understanding. The last paragraph there gives age ranges of birth through 2 and 3 through 5. And it's not clear to me that there's a significant difference in what's required for those two age groups. Like, it seems like it's the same basic requirements across the entire range. So I was not sure if I was missing something that I should be picking up from that part of the policy.
Education policy.
Yeah, the last paragraph.
Lindsay, would you have any information on?
603.
Mhm. The law, yeah. Process. Yeah, so that's not related to any of the Senate File 2498 update. It's just
Right.
essentially states in law. Families pretty much have the ability to have their services if they are entitled or through the child fund, working through the child fund process.
Sorry, I missed some of the question. Maybe she mentioned last time about those.
Oh.
That would be provided written confirmation. That's the impact piece, right?
So reviewing the IEP is K through 12.
Birth to 5
And I think that
or birth to
last
PK.
paragraph is birth through 2 is early access with our ADA partners and then program.
Can you hear that, Jennifer or Lisa?
I was having trouble hearing that last one.
Sorry, the new Senate File 2420. It just is for K through 12. And so that last paragraph there was just stating all the law that we've already been through. Our birth through 2 is served through our AEA partners, and then we support 3 through 5 in our preschool setting.
Okay. Thank you.
About a 5-minute warning here, so if there's a motion.
Motion to adjourn?
Second.
All in favor?
Aye.
Aye. Not,
Thank you, ladies. I'll get the conference line open up here real quick.
Thanks very
Kim.
much.
Thank you.